Mr. Deputy President, I've had the opportunity and I think the very great honour of hearing directly from workers who will be affected by the changes that are before the House tonight. I participated in the first Workers' Comp All You Need to Know in a Day inquiry that was run by the Law and Justice Committee, and also as a participating member in the Public Accountability and Works Committee inquiry. And I think the committee system is one of the great strengths of this House, because in quite complex legislation, such as that we are considering now, it helps to take evidence from experts and to really understand what is happening. And it is quite common in my, albeit limited experience, that bill inquiries will come back with a recommendation that the bill proceed to debate. And I note that recommendation 14 of the most recent inquiry, in fact, came back with that recommendation, but the recommendation is full is that the first bill return to the Legislative Council for debate to allow the evidence and submissions presented to this inquiry, as well as the comments and findings contained in this report, to be considered by members. And I would encourage all members voting on this bill to consider those recommendations and that evidence very carefully. And I point to three recommendations in particular that speak directly to the bill that is before us. Recommendation 3 tells us that the provisions in the bill lifting the degree of permanent impairment thresholds temporarily to 25% and then to 31% should be withdrawn by the government, and if put forward in the House, opposed. This was the considered opinion of the committee that had the great benefit of hearing from doctors, from hearing from lawyers, from hearing from those experienced in the workers' compensation field, from hearing from Treasury officials, from hearing from iCare, from hearing from CIRA, and most importantly, hearing from workers themselves. And the considered recommendation was that if the bill is presented with the 31% threshold unwithdrawn, it should be opposed. And recommendation 4 says that Schedule 1.3 in both the Workers' Compensation Legislation Amendment Bill and the Workers' Compensation Legislation Amendment Reform and Modernisation Bill, which would replace the existing provisions for the assessment of the degree of permanent impairment for an injured worker with a new scheme with a single impairment assessment carried out by an assessor agreed between the insurer and injured worker. If no agreement can be reached, an assessor appointed by CIRA should be withdrawn from the bills, and if proceeded with, should be opposed in the House. A considered recommendation made after the opportunity of hearing directly from people with evidence and experience. And then recommendation 5. The bill should be amended to exclude compensation for claims for a psychological injury where reasonable management action is a significant cause of the psychological injury. I don't intend to speak to the whole bill or even to all of those three very important recommendations. I would like to say something more about recommendation 3, which speaks to the question of permanent impairment thresholds. 31%, you say it quickly, sounds fine. 31% impairment, less than a third impaired. South Australia, 31% impairment, we're just standardising ourselves with New South Wales. Say it quickly, it sounds fine. And I must admit, when I first came to it, I thought, 31%? What? Are we really that worked up about 31%? But of course, 31% of what? What is the scale? What is the measurement tool? How are we judging? What does 31% look like? If anybody is in any doubt, and before voting on this bill, I'd ask you to go to the evidence that the Pork Committee heard, and I'd in particular ask you to go to the evidence of the O'Brien family. And I'd ask you to go to the evidence of the daughter of the injured worker, Mr. O'Brien. Because what struck me listening to that evidence was we're not just talking about the impact on the injured worker. We're talking about the impact on the injured worker's wife in that case, or husband. We're talking about the impact on the children. We're talking about the whole family impact and the hope and the possibility that that family can continue to function. And also, I'd like to actually really congratulate and call out the whole O'Brien family of how they have coped with the very unexpected and unfortunate injury that their father suffered, and the way with grace and love and courage and perseverance they have supported him towards the recovery such as it is that he has. And also their bravery in coming forward and speaking to us about what 31% actually looks like. Because to set the whole person impairment threshold at 31% is simply too high if this Parliament, if this House, if these members truly care about the impact on injured workers. And this isn't just my opinion. So Professor Nick Glozier gave evidence to the committee. And in terms of his qualifications, he has worked in the area of workers' compensation for over 2.5 decades. He's written hundreds of papers on workplace mental health impairment assessment and disability. He was an author of the World Health Organisation's guidelines on workplace mental health. He wrote the World Psychiatric Association's statement in this area. He developed the evidence base for Safe Work New South Wales, which underpinned the guidelines and later the regulations, the evidence of all of the stresses and the interventions for all of that. He developed them, and he actually holds patents in respect to them. I think we can admit that he is highly qualified to give an opinion in this area. And he said, representing the medical college that he was speaking on behalf of, that it looks quite clearly that the legislation has been intended to further discriminate against people with severe psychiatric disorders. The changes from the draft exposure have appeared to have removed the focus on limiting entry into the system and begun to focus entirely on the severity of people's psychiatric disorders. And then I think this really important thing that everybody should think about before they vote. Raising the threshold, this is the 31%, raising the threshold to a level that we see as ridiculously punitive, such that almost no one will ever get compensation for a psychiatric disorder. Therefore, almost no one will ever be able to proceed to work damages claims. And that is entirely consistent with the evidence that I heard in both of the inquiries on which I sat. Lawyer after lawyer with decades of experience, doctor after doctor with decades of experience, essentially told us that having reviewed their files, almost none of the people that they had treated, almost none of the injured workers whom they had treated, almost none of the mothers and fathers, husbands and wives whom they had treated, would meet the threshold that is contained in this legislation. And we have to ask ourselves, is this really who we are? Is this really what we are saying to the workers of New South Wales? So the threshold that's to be lifted to 31%, there are 4 components in that. The threshold for any ongoing weekly payments, the threshold for compensation for needed treatment, threshold for lump sum payments for non-economic loss, and the threshold for modified common law damages for an injury caused by negligence or other tort of the worker's employer. I only want to speak to one of these aspects, and that's the threshold for the compensation for needed treatment, service and assistance. So what we're doing is lifting the threshold to an almost unattainable 31% for workers to continue to receive payments that will provide for them the treatment that they need to hopefully recover and return to the workforce, or if that is never possible, which sadly is sometimes the case, at least to go on living functionally, one hopes, with their families and in their lives. And I'm quoting again from the report and the evidence that, if anybody's interested, you find at page 26, where, in fact, I'll start at page 25, where Associate Professor Michael Robertson said that injured workers with a degree of impairment between 21% and 30%, quote, are a very damaged group who often have had a very long pathway into their psychological injury, and it's more a challenge of care rather than cure. And this is the group that we are saying are too well to receive continuing support for their psychological care. And it was clear from evidence given by Michael Coates-Trotter, the Secretary of the New South Wales Treasury, that indicated that the government was relying on NDIS to provide support for injured workers. But of course, as the report notes at 3.47, the NDIS does not replace community mental health services or treatment services provided through the health system. It funds psychosocial recovery supports that focus on improving a person's functional ability. So, if we are withdrawing support from these injured workers who need it, and if the NDIS is actually not available to them, then what we're looking at is mental health treatments for injured workers with a psychological injury and a degree of permanent impairment between 21% and 30%, after 3.5 years from when the injury was occurred. Their only avenue will be the public mental health system. Now, we are all committed to a strong public mental health system. We all want a public mental health system. And we all know that there are major holes currently in that public mental health system. So what are we doing? We're saying we take these people who need. And why do they need? Because they went to work. They were doing what we ask everybody in our society to do. They were participating in the economy and they were injured at work. And then we say to them, well, we'll help you for a bit, but now we're upping the threshold. No more supports for your treatment. And good luck finding somewhere in the public mental health system that might be able to support you. This is not good enough. And if this is the answer that this bill is providing, then this is not an answer that we can support. This bill needs significant amendment in order to treat our workers with respect and to recognise that psychiatric injury, psychological injury is real injury. I think one of the most egregious things that this bill does, and one of the problems I have with this bill, is that it has one threshold for physical injury and another threshold for psychological injury. What have we been trying to do for decades? We have been trying to say that psychological injury is real. If you break your leg, that's real. If you break your psyche, or worse, if it gets broken at work because of unsafe systems over which you had no control, that is a real injury too. This bill, with the current iterations of the thresholds, is a retrograde step because it says that we actually don't treat psychological injury in the same way that we treat physical injury, and it puts a big question mark around whether we actually believe in psychological injury. And I think that undoes decades of work and is yet another reason why the bill, without significant amendment, must be rejected.